Okay. Well, good morning, everyone. Thank you so much for being here today and for doing this training. We are continuing to provide services regardless of what's going on in the world. So this is something that we hope will continue to expand our ability to take on these type of cases in the future as well, not just during a time of need. But again, my name is Regina Hernandez, and I am a staff attorney at Legal Aid Chicago. My work primarily focuses on the development of pro bono projects like this one to help expand our capacity to serve our clients where there is the most need but limited resources. Our criminal records relief project is one of those ventures, and today we will be focusing on how to navigate the expungement and sealing process with the hope and expectation of using this newly acquired knowledge to help provide these services to our clients yourself. Next, please. So the training today can be broken down into two main components. I'm going to teach you both the substantive law surrounding expungement and sealing in Illinois, and subsequently how to then apply this to taking on pro bono cases from Legal Aid Chicago. Next. So this work is in high demand because of the detrimental collateral consequences a criminal record can create. The most obvious and commonly known effect is with regards to employment and the barriers created during the background check portion of the job application process. This effect is substantial and it impacts so many of our residents in Illinois as well as the rest of the country. Additionally, I should note that criminal records can not only impact somebody's ability to find a job, but can impact someone's ability to secure stable housing, secure financial assistance, obtain vocational license, and even impact one's ability to seek higher education. So the thing to keep in mind as you're taking on expungement clients is that one of these areas can easily affect the other. And as you take on more and more clients, this becomes more and more apparent, this kind of domino effect that takes place. Next. There are three major steps in this whole process. Records research is first. This has to be done to ensure that we have the most accurate information available about each and every one of a client's arrests and charges. This is crucial in determining someone's eligibility for relief, and it's something that Legal Aid Chicago takes care of prior to any pro bono attorney taking the case. It is something that we have hopefully perfected over time, and we hope that it makes it a little bit easier to then complete the necessary documents that need to be prepared, which is the second step. And this is your primary task. So your task will be to take that information that we provide and prepare all the court documents necessary to ask the court for relief. This can be an incredibly time-intensive process because of how detailed these documents need to be, but it's why I can't stress enough how much this portion of the work matters, because us being able to do, just between me and Melissa, do one at a time, this really impacts our ability to serve as many clients as we now currently do with the help of pro bono attorneys. And once you start doing these petitions, once you start working on these court documents, you really realize the level of service that you're providing to clients who would have to otherwise navigate this themselves. Once the paperwork is done, Legal Aid Chicago steps in again, and we file every client's petitions. And because we want to focus on extended representation, we will go to court for the client as necessary. Next. An important part of understanding the law of expungement and sealing is to understand what a person's records are and where arrests and charges appear when they are created. We look at three primary places for records: rap sheets, statewide police reports, and the Cook County clerk system. For your purposes, the most important thing to know about these records is that inconsistencies and lack of information is extremely common. So sometimes when you get a case from us, we might specify, hey, please let the client know that they need to provide us a copy of their Chicago Police Department rap sheet because they only provided the statewide report. We try to work with whatever the client gives us, but for Chicago specifically, for example, it is required that we attach a copy of the CPD rap sheet specifically to the court documents. Additionally, the thing to note that might be a little bit confusing for a client who maybe does have to get us an additional arrest report or something like that is that the statewide police report, as our kind of go-to example, it would suggest that it includes everything in the state that a client has ever had any kind of interaction with law enforcement on. This, by and large, is not the case because not everything is required to be forwarded to the Illinois statewide police. So that's where the rap sheets come in. And typically, the Chicago Police Department rap sheet is the more reliable one, and I say that without taking that to heart too much because there are still problems with it as well. However, the Chicago Police Department uses a system called iClear that a lot of different law enforcement agencies use in the state, and so it tends to provide not just the Chicago arrests that a client might have, but some arrests outside of Chicago. The third thing that we have to check now that we've cross-referenced both the statewide police report and the rap sheets are the clerk system. My general rule is clerk system rules all. So even if the rap sheet says that a particular disposition happened, that it resulted in this particular sentence, I always double check the clerk system because it is the record of the actual court file and court proceedings. And so that is really important for us to always double check. And that's part of the reason why we try to take that portion of the task ourselves because we have access at our office. And it's something that we're very diligent about. And if a client has any issues with what's appearing in the clerk system, that's something that we'll certainly deal with independently. But for your purposes, again, this is just to understand the research that we do and the cross-referencing we do to make sure that we have the most accurate information for that client and make sure that we're catching everything that we can so that we could actually get rid of it. Next. So when we're looking at these different documents, what specifically are we looking for? Well, one of the first things that we need to determine is whether an arrest resulted in a conviction or a non-conviction. This isn't determined as simply a not guilty, guilty verdict. We also need to look at any sentences the person received and whether or not they completed those sentences satisfactorily. This distinction between convictions and non-convictions is defined by state law. So a lot of clients get a little bit confused when we tell them that a particular charge resulted in a conviction and we hear back, but I just did probation or I just had to pay a fine. Unfortunately, by state law, probation, conditional discharge, time considered served, prisoner jail time, boot camp, and fines for municipal ordinance violations are technically considered convictions. Additionally, if you look at the list of non-convictions, this is not just not guilty, I should say, or dismissals. These also include supervision and some special forms of probation that are typically associated with drug-related offenses. Now, if someone completes those special types of probation or supervision satisfactorily and do everything that the court has asked of them, then by law, they will be considered non-convictions. However, the second that one of those is not completed satisfactorily, it does then become a conviction. And that's important when a client has a little bit of a complicated record and has questions that would seem like, yeah, that makes sense that you weren't found guilty or you just did this type of supervision. it's going to depend. And that's what we're looking at, because ultimately, what's eligible for expungement is only non convictions. What's eligible for sealing are convictions. And that's the important distinction there. Next. So, what is the difference between expungement and sealing? So once we have found that disposition information and we've determined what was a conviction and what was a non-conviction, we then can determine the type of relief a client is eligible for. Expungement is what everybody is aiming for. If you have a record expunged, it's as if it never happened. Sealing is essentially hiding the records from general public access. If a record is sealed, generally speaking, it is often just as effective as expungement, with the most significant difference being that sealed felony convictions would still be available to entities who are authorized by law to conduct a fingerprint-based background check. Now, again, I completely understand when clients get disappointed when we tell them that this only is eligible for sealing. It's going to depend, the effect is going to depend on the circumstances and the client's goals. So again, stress the fact that it can be just as effective as expungement, because generally no private or public entities can see sealed misdemeanor convictions. It's just those most serious offenses that there are certain entities that take a special interest and are thus authorized by law to conduct those fingerprint background checks and see those sealed felony convictions. The most common example, and it's one that I get all the time, is for somebody who's applying to work for Chicago Public Schools. They have a special public interest in knowing about any felony convictions, regardless if they are sealed or not. Next, please. When we've determined what type of relief a client qualifies for, we also need to check for two more potential barriers. The first is whether or not that client is subject to any wait periods. This can get a bit frustrating for clients because for even those SOLs and non-suits, which if you have any experience with the criminal division, are some very technical distinctions, even though they're still all considered dismissals, acquittals. It's important to understand that with stricken on with leave to reinstate and non-suits, there's still technically a wait period of 120 to 160 days from the time that actually that date where it was determined that it was stricken. But by and large, this is not a huge issue. The issues come into the longer wait periods. So for most supervisions, even though it's a sentence that, when completed satisfactorily, does not result in a conviction, it's still something that takes 2 years to expunge from the end of supervision. So when that supervision was completed satisfactorily, that date, the clock starts ticking starting then. And it is 2 years to expunge that particular technical non-conviction. It's 5 years to expunge supervisions for domestic battery, criminal sexual abuse, and for those qualified probations that we talked about, that are those special types of mostly drug-related probations. There's a little bit longer of a wait time to actually expunge those, pretty much just based on the fact that they're more serious offenses. Now, the most common problem that we encounter is with regards to sealing convictions, generally speaking, because it's 3 years to seal convictions from the completion of the last sentence on someone's record. So that means if someone is still in a wait period from their last conviction, no other convictions can be sealed. So if I had a conviction for some kind of drug possession in 2000, was subject to a 1-year probation, which ended and I did everything satisfactorily by 2001. If I don't do anything to seal that conviction at that time, and subsequently pick up another conviction, let's say for driving on a suspended license in 2019, then I cannot expunge that old, or I cannot seal, I'm sorry, I cannot seal that old 2000 conviction because the clock starts again from that last sentence. So let's say for driving on a suspended license, I just got 2 days jail time. As soon as I'm released from jail, that's when the clock starts again for those 3 years. So that can be a bit of a technical frustration, but this is something that we have to screen for because it is a very common objection if we don't do that correctly. Next, please. The second thing that we need to double check after we've done this initial record research and determination of convictions, non-convictions, and wait periods is we need to double check if that client has any charges that do not qualify for any type of relief. Convictions for domestic battery and violations of orders of protection are never eligible for relief. The same with convictions under the Humane Care for Animal Act. So most commonly, that's those animal cruelty charges that we see every once in a while. Sex crimes, specifically those that require you to be in a public registry, are not eligible for relief. And DUIs and reckless driving, even if you just receive supervision. And the DUIs, convictions, or even supervisions are something that come up all the time, but we have to just specify that by law, this is something that we can just never ask for relief on. And it's just something that unfortunately won't go away. Next, please. Okay. Now, making sense of these criminal records when we're doing this process and making sure that we have all of the information needed to determine eligibility can be a lot to absorb. But what we have done is broken everything down into just the necessary information through something called case charts. So in the materials provided for you, you will have a full case file for our make-believe client, a Mr. Emilio Expungement. You should take a moment to look at these materials and specifically note the sample case chart provided. This is going to be the key to completing the court documents. Everything you will need is easily transferable from the case chart to the court documents. There are very, very similar case charts that are in the petitions themselves that are asking for relief. So that's why this case chart model we did in the manner that we did. We want to make it as easy as possible with some very confusing paperwork to make sure that it's easy to just put the necessary information that you need for the actual court documents. So the information that will be provided for you on the case chart includes everything from the case numbers and final charges to the dates of arrest, the dispositions, the sentences, and we have some additional identifying information that we're required to put in there, which we typically use a CB number. That CB number that you see in the middle there, that is a central booking number. It is just another way to identify a particular arrest and charge. This is also because not every arrest necessarily results in a court case being filed. So sometimes people are just released without charging, and there is no case number to associate that particular arrest with. However, every time you are arrested, it creates a record, and it's not something that goes away automatically. So there's still something to do, there's still something to get rid of, and a CV number or other identifying number that you might see, like a document control number, that's something that you might see on a case chart as a reference to something where either that person was released without charging, or we searched high and low and could not find an associated case number for some reason. This is most common with a lot of older cases, but again, we have tried to do all of that records research and get all of those really specific complications taken care of for you prior to you taking a case. What you should note for your purposes in helping you determine what court documents to use and what exactly you'll be doing is to take special note of the district number, the arresting agency, and eligibility, because these are essentially our notes to you, letting you know what type of paperwork you're going to need. In particular, in the eligibility column, we not only specify whether that person's individual charges are eligible for expungement or sealing, but we specifically reference the exact document that you're going to need to use. Next, please. So what exactly will you need to complete for the court documents? Simply put, notices, petitions, and orders. The notices, you have to notify everyone who could potentially have an interest in this person trying to expunge or seal their record. We must notify the Cook County State's Attorney's Office in that district, the Illinois State Police, the local arresting authority who actually arrested our client, and the attorney for the municipality where the arrest occurred. So for Chicago, that's generally Corporation Counsel. This is information that will be provided to you for other districts. So please try not to worry too much about that. But generally speaking, just know we have to notify everyone who would potentially have a reason to object. Second, you're going to complete petitions for all arrests that are eligible for expungement and a separate petition for all arrests eligible for sealing. There are actually 3 types of petitions, even though there's only 2 forms of relief, but I'm going to get into more details in a couple of slides, specifying specifically what the difference is. Additionally, you are going to need orders granting and orders denying. So for every petition that you complete, you need an order granting and order denying. If you're completing both an expungement and sealing petition, that expungement petition needs its own separate orders, and the sealing petition needs its own separate orders. And this is really just for convenience of the court, where they could essentially put whatever case numbers they're granting that particular expungement for on one, and if there's any in particular that they're denying, they can put it on the other. It's very much for convenience purposes. Next, please. So here's where the paperwork gets a little bit tricky, and please bear with me. I promise this will make sense. When you are completing this paperwork, the thing that you have to keep in mind is that there are 6 municipal districts in Cook County. This means we have to prepare at least one set of court documents, which is notice, petitions, orders, for each individual district that applies. So let's say our Mr. Emilio Expungement was arrested by the Chicago Police Department and the Maywood Police Department. Even though these are both Cook County arrests, you will still need one set of court documents to file for just the Chicago arrests and one set for the Maywood arrest, because Chicago is District 1 and the only municipality within District 1 is Chicago, and Maywood is in District 4, for which there are many municipalities, which we'll touch on in a moment. Within each district, you also need to complete a separate set of documents per arresting agency. So let's say our client Emilio was arrested in both Oak Park and Maywood, which are both within District 4. The Oak Park arrest will need its own notice, petitions, orders, as will Maywood. For the purposes of the notice, as I briefly mentioned earlier, this contact information will be provided for you because there is something already pre-prepared for District 1, since it's going to be the same information every time. But for the general notices that you'll have available for Districts 2 through 6, because they include so many different municipalities, that's something that you need to manually put in yourself. But we've already done that work and provided that information for you when you take a case. Next, please. So here's how I like to break it down once we get a case chart in front of us and we've already separated everything. So from here, you're looking at Emilio's case chart, and one of the first things that I recommend that you do is to at least separate by district first. So from this, you can tell that Emilio at least will need to file in 2 separate districts. So for these districts, you also want to look at the eligibility. This is again predetermined. So what you'll know from this is if District 4 only has the 1 arrest and we've said, okay, this needs an expungement no fee petition, then you are going to complete 1 notice, 1 expungement no fee petition, an order granting, and an order denying the expungement. And then you see that there are 3 District 1 arrests, but a couple of different forms of relief. You have an expungement fee petition and 2 charges that ultimately resulted in convictions that would only be eligible to be sealed. So even though this is all 3 arrests are in District 1, there are 2 types of relief that are represented here that we need to account for. So you will need 2 separate notices. 1 notice for the expungement fee petition and 1 notice for the sealing petition. And for the expungement no fee petition, again, that gets its own orders. And for the sealing petitions, that gets their own orders. If there's one general takeaway that I can give you, as to put it as simply as possible, I think the best way to think of this is for every arresting agency that arrested the client, there should be a separate notice. And for every type of relief being asked for, there also needs to be a separate notice, even if there are multiple arrests within the same arresting agency. If you're asking for a different form of relief because you have to use different paperwork, you should include a different notice. Next, please. So with the notices, like I mentioned, the notices that are provided for you in digital form, there are 2 different types. There is the Chicago specific notice that is already pre-filled out by Cook County as it pertains to making sure that we're notifying CPD, Corporation Counsel, the state's attorney's office, and the Illinois State Police. But then for districts 2 through 6, because there are so many municipalities within these districts, they are just essentially blank notices that you will need to fill in yourself. Again, that information has been provided for you. The only things on the notices that you should really make sure that are included are the case numbers for that particular set of documents. So if you had, let's say for Emilio, 2 additional arrests that were dismissed in Cicero, which is still District 4, just another arresting agency other than Maywood. This means for filing in District 4, you would actually need to prepare 2 separate notices because you're talking 2 separate arresting agencies and 2 different forms of relief that you need to be preparing documents for. Additionally, the checkboxes at the bottom, again, should be an indicator for you of how we should separate these. You need to make sure you have a separate set of documents for each form of relief and each arresting agency. And so you will help kind of keep it separate in your mind by checking those appropriate boxes when you're dealing with the same arresting agency and multiple forms of relief that we're asking for. Next, please. So I keep referring to these no fee petitions. These petitions are broken down into 3 categories. There's expungement no fee, expungement fee, and sealing petitions, which always require a fee. Now, again, I realize that it's a bit confusing that there are 3 types of petitions for only 2 forms of relief, but this is how the county has broken them down. Basically, for all of these arrests that resulted in dismissals, acquittals, and not guilties, those very, very clear non-convictions, the thought process is you shouldn't have to pay a fee, and thus you use a no fee petition. For all of those arrests that resulted in those special types of probation that I briefly mentioned, or supervisions, where they will technically not be considered a conviction and thus are still eligible to be expunged, because there is still some level of culpability, it's a form of relief that the court says you still have to pay for. And finally, for sealing, this is the easiest one. For everything that resulted in the state's definition of a conviction, those are the only charges that go on this petition where a fee is required. However, please note, even though we still need to use these 3 different forms that indicate a fee would be required for 2 of them, anyone represented by us will not have to pay any associated court fees. We file a version of a fee waiver on behalf of the client that is specifically used by free civil legal service providers. So we have to still keep them separate on the petitions for the sakes of the clerks and for the court, but for our purposes, we will not be paying any fees. And I just want to make sure that when sometimes clients see that a fee is required, they get a little bit nervous, but as long as we're representing them, they will not have to pay any fees. Next, please. You'll notice when you look at the petitions and you really sit down with them that there are those charts that are similar to the case chart we used to put arrest information on, but there are also a number of check boxes with statements that are a little bit confusing. They're phrased pretty poorly, but it helps to read them as the petitioner's arrests on this petition were ... and then whatever the rest of the statement is essentially asking for. For the arrests that are on that particular petition, you want to check every one that applies. So in this particular case, this is a sample of the statements that you need to read through and check on a petition to seal. The first statement that's there, number 2, is essentially saying the arrest was not a felony offense unless the felony charge was amended to a misdemeanor or otherwise eligible to be sealed. So if on that particular petition there are there are misdemeanor charges or otherwise eligible to be sealed, you should be checking that box. The number 3 checkbox, the petitioner's arrests resulted in orders of supervision or convictions that are subject to sealing, and she earned a high school diploma, associate's degree, and a number of other vocational or educational degrees. Now, in this particular statement, it's referring to a waiver of a wait period that we screen for when we're reviewing the client's eligibility. On the case charts that we'll provide for you, there's going to be a section at the bottom for notes. We like to write all sorts of little love notes to our pro bono attorneys that helps clarify some very specific details about that client's record, because we want to provide the most general training that we can while still being as thorough as possible. And for this particular instance, if somebody, while they are still serving their sentence or they're on parole, if they earn some type of vocational or academic certificate, degree, then that technically waives those wait periods that we were talking about when it comes to actually sealing something that would be subject to that 3-year wait period. Now, we will specify that because that's something that we will look at beforehand. So again, everything that you need to help fill out these petitions is in the case charts. If it's not within the boxes themselves, we will indicate those specific details and those special circumstances in the notes provided. So again, these statements that you need to check are a little bit confusing and certainly leave something to be desired as it pertains to how they're worded, but just take the time to read through them. They do make sense if you just mentally simplify it for yourself, and ultimately do the best that you can. Please try not to stress on this in particular, because this is something that is so easy to correct once we do a final review. Next, please. This is the part I hate. uh, this process for expungement and sealing is a lengthy one, but this is why we should stress to a client that it is so important that they are getting this started as soon as possible. In District 1, unfortunately, which is Chicago, and it's the biggest district and it's the one that is most common, we are not receiving responses for 8 to 12 months. And right now, it's about at that year mark. In districts 2 through 6, the time varies from district to district, from anywhere from 60 days to approximately 6 months. And we will typically let a client know what to expect if they have suburban arrests. But again, generally speaking, we know that this is incredibly difficult to hear, especially for clients who are not in the best of circumstances and are trying to find employment or trying to get some type of higher education or financial assistance. It's absolutely understandable that that client would be frustrated. But again, I like to try to just be as glass half full as I can be and let them know, because it takes this long, this is why it's amazing and it's so great that you're getting this process started now. And if that client, when you speak to them, have any specific concerns, like, during this time period, they are facing homelessness or they recently got fired for a job, if they didn't let us know when we did the initial intake, please feel free to make note of that and let one of us know, hey, I spoke to this client, told them how long it takes, and it looks like they just recently got fired for a record that came up. Let us know, because potentially there's something else that we could look into. There are other types of relief that are more alternative to this that we could try to explore, and it gives us a better sense of the client goals overall. So we are realistic and we understand that this isn't ideal, but we will try to assist them however we can. Next, please. So clients may ask you, especially after you let them know how long this process will take, they may ask you, okay, so after I've waited all this time for the process to finish, what does that mean for me when it's over? Generally, if everything we ask relief for is granted and the client has no ineligible charges left on their record, the only potential future charges that should ever come up again are sealed felony convictions. But again, like I mentioned before, they should only come up for entities authorized by law to conduct those fingerprint-based background checks. Additionally, we do have ban the box in Illinois, but a lot is still not necessarily understood to the general public because it gets very specific. It's true, an employer cannot ask you about arrests on an initial job application, only convictions, and only after the initial job application process has started. And that means it's after an interview, tentative offer, something that is more than just that initial first contact. If their record has entirely been expunged or sealed, they can answer no to the question, have you ever been convicted of a crime? Except when that employer is authorized to do fingerprint-based background checks. You would then have to be forthright and let them know. This is something that ends up getting subject to a lot of hypothetical questions from clients. And I want to make sure that a client understands that because this is a very detailed law and there are exceptions, including how many employees that employer has, and if it's outside of Chicago, we want to make sure that we're not giving them misinformation. If they have specific questions about a specific job they applied for or some other specific hypothetical, you can absolutely note their concern and you can have them speak to one of us. And we will always follow up as necessary and we're happy to look at specific circumstances. But generally, we want to try to stay away from hypotheticals. We have to see how this whole process ends up first. If everything gets granted, if nothing gets granted, we have to wait for that outcome. The only kind of exception that I would note if a client happens to mention it is juvenile records. Only some entities are ever permitted to see a juvenile record, regardless of expungement or sealing. And juvenile records over the years have had newer and newer laws to actually create punitive measures for people who do somehow get their hands on juvenile records. So if somebody brings that up, certainly let us know. We have a juvenile expungement help desk as well that can assist with those matters. Next. In our little love notes that we will put at the bottom of a case chart, you might see that a client is required to submit a clean copy of a drug test. If a client has a drug-related conviction we are asking to seal, it is required by law, not by us, that they submit a copy of a clean drug test when we file the petition. We typically have been asking for a 10-panel drug test. There is not a specific requirement that is statutorily required. It just says all illicit substances need to be screened for. So far, this has been fine. We know that this can get a little bit pricey. So if a client has specific concerns about that and maybe a 5-panel is cheaper, then absolutely open that conversation up to us. We will try to work with whatever the client is able to get. Additionally, if you let the client know this and they say, oh, I have a copy that I just got from an employer background check for the last job I applied for, it has to be taken within 30 days of filing. We will let that person know when they should go ahead and get that drug test, because we typically will not file until we get that copy of a clean drug test, and then we file almost immediately. But if there's ever any delay in filing, like court closures, we want to make sure that that person doesn't waste like $60 and then we can't even file the case because of court closures. So we will let that person know, but they should still be prepared and just know this is why you need a copy of the clean drug test. Now, after January 1st of 2020, technically the presence of THC should not be a problem for anyone over 21. However, these forms of relief are discretionary, and it's worth considering at least that a judge may still not like it. You never know with the judges you might get that day, especially if you're trying to seal other drug offenses. If it's really a question of preference, I prefer a completely clean drug test, but I am happy to go to bat for somebody who only has THC in their system and they're over the age of 21. It should not be a problem. I certainly believe that it should not, but we want to make sure that that client is aware of the potential risks, because we just don't have enough data to really properly say what's happening in the courts if THC is present in somebody's system when they're required to submit a clean drug test. Next, please. Speaking of THC, what about cannabis charges? We had this great new law that took effect January 1st of this year, and it provides for a lot of different forms of relief as it pertains to cannabis charges and cannabis convictions. The biggest takeaway that I think everybody should really grab from this is we don't want to rely solely on automatic relief. We are assessing everyone individually on a case-by-case basis, because something that might apply to one person might not apply to the other. Eligibility for forms of automatic relief is still a little bit confusing, and it's not quite perfect yet. And we are trying to track this as best as we can, but it is still a relatively new law. And the timetables are not necessarily ideal for a client who has certain offenses on their record that keep coming up. Right now, there is a priority to take care of cannabis charges that are eligible for some type of automatic relief, that are those newer charges, because the thought process is those newer charges would potentially have more of a negative effect than something, say, in 1999. However, again, we understand a client's eagerness to get rid of these cannabis charges that would be eligible, but we have to look at those very specifically, and we need to make sure that they qualify. And I'm also going to check if that particular case, if it's already been filed by the state's attorney, because as you can see, for cannabis possession, manufacture, delivery, possession with intent to distribute, these misdemeanor and class 4 felony convictions, we can individually petition the court to vacate and expunge these convictions or wait for the state's attorney to do so. And the thing that was most noted was when the law was first enacted, I think it was a couple of weeks afterwards, that Kim Fox filed all these vacature and expungement petitions. And it was great, but it really just scratched the surface. So we're still checking to see if there's been any movement on these cases at all, if something's been filed on their behalf, before we go ahead and try to take some action ourselves. But just to let you know, we are taking all of this into consideration and looking at this on a case-by-case basis. Next, please. And on that note of a case-by-case basis, we are doing vacature and expungement motions for those more serious cannabis convictions. It's a different process that we are still trying to perfect ourselves. So the general statement that you should make to clients, if our little notes at the bottom of a case chart don't indicate so, is that Legal Aid Chicago is going to be assessing these individually, because it really is just a separate form of relief at this point that we want to make sure we're advising appropriately on. And if they have any specific concerns regarding these offenses, you can let the client know that Legal Aid Chicago can answer those questions and provide our contact information. Next, please. So you're ready to take a case. What can you expect? You will be assigned a client, and you will run a conflict check using the information provided. Then, once conflicts have cleared, you're going to receive your digital case file. This digital case file will include that case chart for you, the digital fillable court documents, a CLSP, which is that fee waiver I previously mentioned. Not everyone is familiar with it, so I will go into the specifics of what that is. And notice information for the suburban districts will be provided if applicable. Once you receive that digital case file and have a moment to really sit down with it, look through it, make sure you're getting your bearings, you're then going to start preparing those court documents. Once you have prepared those court documents, you're going to then call your client to explain eligibility and next steps, in addition, of course, to who you are and what your role is. And once you're done with all of that and the client understands eligibility and next steps, you will then email the completed documents back to Legal Aid Chicago. Next, please. The magic of a CLSP. So, like I mentioned, even for fee petitions, our clients will not pay any fees. An additional document you will prepare is called a CLSP, or more formally known as a Rule 298 certification for waiver of fee representation by a civil legal service provider. You're going to create one CLSP for each petition you complete that includes all the case numbers in the caption for that specific petition. All you have to do is fill in the client's name and case number and relevant case numbers on each CLSP. So just make sure that every case number is accounted for, so that we're asking for all of those case numbers to have their fees waived. And again, all you need to do is fill in the client's name where appropriate, which is in the caption and in the body of the text itself, and every applicable case number for that particular petition. And that's something that you'll send back to us as well. And that's something that we sign after we are done reviewing everything. Next, please. So when you call your client, here's generally what you should discuss. Of course, have an introduction of who you are, what your role is, and the purpose of the call. They are going to be potentially talking to a number of different people through this process, both you and various staff members from Legal Aid Chicago. So you want to make sure that they understand who you're talking to and who you are and who we are. After that, you're going to start explaining their eligibility using the case chart and the notes that are provided to you from Legal Aid Chicago. You do not need to do this line by line. You can highlight and summarize everywhere where is appropriate. So if there are particular charges that were ineligible, that's a pretty important thing to discuss. So that's something that you should discuss individually, but otherwise you can summarize the forms of relief that that particular person qualified for. Then you are going to explain next steps. You're going to remind them who their attorney of record is going to be. It's going to be Legal Aid Chicago. Legal Aid Chicago will review the documents after you get everything back to us and arrange for signing a retainer for representation along with the completed final petitions at a later date. As soon as Legal Aid Chicago is able to, we will then file their paperwork with the court. If the client needs to submit a drug test, please tell the client not to obtain one until contacted by Legal Aid Chicago. Again, as I explained, I do not want anybody rushing out to get one, especially because everyone should be staying at home at this moment. But in general, we want to make sure the timing is absolutely in line with when we're going to file so that there is no expiration on the drug test. You're also going to explain how long this process takes from the time of filing, and of course, have that extended conversation depending on what their individual concerns are, and let us know of anything that is really substantial that the client has questions about, and you can contact us, of course, anytime. Next, please. There are some things that I like to keep in mind for anybody who is working with criminal records clients for the first time. The first is you really have to try to earn that client's trust. Emotions often run really high when it comes to criminal records, and the thing that I think we all need to always check ourselves on is that we are not here to judge, place blame, or challenge someone's accounts of the circumstances around their records, because many people feel like this justice system has done them a disservice, that they were wrongfully convicted. There's all sorts of things that a client's emotions can be really high about when it comes to their record. And you need to make sure that you're managing that appropriately and making sure they understand this may not be the right venue for you if all you want to do is try to overturn a conviction. That is not the purpose of this process. But again, not saying that they're necessarily wrong, but this is solely what we're doing: expungement and sealing and any other kind of post-conviction relief or just criminal records relief in general. But in terms of doing more criminal defense work, that's something that we just unfortunately do not do, will not do. And we need to make sure that the client understands that we are just interested in making sure that whatever barrier they're facing, whether it be employment, academics, financial assistance, that this is the process that we're trying to complete, and that we are not here to be critical. They do not owe us an explanation about what happened. If we needed some additional information, then that is something certainly that we can discuss in the future. But for now, just try to establish that trust, that relationship. I've had a lot of clients feel very embarrassed by their records, and that's not what I want. I want them to make sure that they know that these are our attorneys who care, who trust, and who are just trying to get them this form of relief. Additionally, you need to try to manage expectations appropriately. As I mentioned, these forms of relief are discretionary, and we cannot guarantee a positive outcome. And that time period that they would have to wait for this process to actually complete, or for certain wait periods that are imposed by law, that is not something that we can control. And we are not saying at any point that this is the magic cure-all for all of their barriers that they're facing, but is certainly an important and substantial step that they can take. And so I just like to make sure that we keep in mind this is still something that is left up to the court and a judge to decide. And we need to make sure that they understand that there is always a chance that they might not get this relief, but we try to do the best job we can to do a very thorough assessment on the chances for each client. Next, please. And thank you so much. We are here, Melissa Pachola and I are both available for questions at any point throughout this process. I feel very confident that any of the attorneys that come to us eager to do this are more than capable of handling this entire process, but we know that it can be a little confusing, and I just want to make sure everybody rest assured that we are here with any and all assistance that you might require. So thank you so much for just sticking with us. And there is Melissa's beautiful face again. And I will go ahead and we'll open it up for questions.
So Regina, we did get one question in the chat about how clients have come to us for this work and how long ago typically, so that the pro bono attorney is aware when they call the client. And if it's okay with you, I can answer that.
Oh, absolutely.
So the answer is that they've come to us in various ways. Some of them have been referred by organizations they're working with. Some have just called our helpline. They have all recently been contacted by us to complete a full intake. And so for the most part, no one has been waiting that long to be in contact with us. And they've been in contact typically with a staff member of ours named Natasha, who's a paralegal who works with us. So some clients have been waiting a couple of weeks, some almost a month. And we did have to reschedule a clinic that was to be in person, but all of that has been explained to the client. If the client has particular concerns about how long it's taking or wants to be able to be followed up with, you can just refer those back to Legal Aid Chicago, and we'll make sure that that client's concerns are addressed. So Regina, this is a question I don't know the answer to, so I hope to learn something. Does expungement or sealing affect eligibility for TSA recheck or global entry?
That is a great question. As somebody with global entry, and I am familiar with the application process, it's not that it will affect your eligibility. It's more that the criminal record itself could potentially affect your eligibility. The thing that expungement and sealing could potentially make difficult, and this is something that is similar to our statement for anyone who is a non-citizen who would potentially be applying for a type of adjustment of status in the future, is that this is an entity that will still have access to your general record, including those felony convictions, and you're going to need to disclose everything to them, regardless of expungement and sealing. What expungement and sealing would potentially do is make it more difficult for you to obtain things like certified dispositions, the court file itself, if that's something that they end up following up with. Now, with TSA PreCheck and global entry, they might just flat out deny you and not ask for anything, but it's not, again, the process itself wouldn't necessarily affect eligibility. It could potentially affect how you would provide additional information to them as they're considering you for global entry or TSA PreCheck.
I have one question for the smart people at Legal Aid Chicago. When we're talking to our client and they're asking us how has the court closures due to COVID, how is that affecting this process? What should we tell them?
So right now, I don't believe that I can file a petition. Okay, so the court closure prevents me, and one of the things to note about expungement or sealing is you cannot e-file those petitions. So we physically have to walk into court with our copies. And so as of this moment, I cannot do that. The moment that I can, I will. So the short answer is, as soon as we are able to file your petitions, we will file them. But as of this moment, we cannot. If the client, and typically what we do is after we file those petitions, we send a copy of the stamped petitions to the client so that they will know as soon as we file.
Okay, so we should basically tell them we're doing this all now so that the petitions will be ready to go the minute the courts reopen.
Exactly.